Daly.
Thanks, Cian Corla, and the Minister will be delighted I won't be taking my full time on this. And without disrespecting anybody involved in the process, it has been described by somebody in my office that this legislation is a bit like a mega snooze fest. And as I say, that's not disrespectful. It's very titillating and amusing to look back at some of these old statutes and laugh at how things used to be done and so on. And obviously nobody is going to object to having them tidied up, but I think it is slightly ironic and sums up in many ways the irrelevance and how much and out of touch this Parliament is, that we are giving time to discuss this now. Undoubtedly the Dáil will probably close early today because there won't be too many people speaking on it, because really what can you say about it? While the attitude of the nation is engaged on the sale of Sightserve and the controversy around that, and we really should be given time to discuss that. And while I'm delighted that there is a row between Minister Noonan and his former colleague Mr Dukes, it's nice to see that coming to the surface, but we should be really using time in here to discuss these issues rather than that. I think there is a certain irony in that situation. We have before us a bill where 5,702 instruments are being revoked, all of them really secondary instruments, the likes of sort of the proclamation giving currency to new pieces of silver money, or the proclamation providing for the election of a new Scottish peer and so on. And it's grand that they're all being tidied up and scrubbed, but I suppose the more interesting ones are the ones that are being retained, and the vast majority of them relate to names and coats of arms. For example, the licence to William Burton to use the surname and arms of Cunningham. And, you know, we kind of wonder what's so important about William Burton's relatives getting to carry the name and arms of Cunningham, but maybe the Minister can enlighten us on that later on. But for me, the more important one, to be honest, is the retention of the historic statute in Irish law that is a proclamation against illegal warrants by some sheriffs and justices of the peace that omit to name the persons against whom they are granted. Now, we're retaining that, and I don't have a problem with that. I'm actually glad, but I think there's a sad irony that we're proclaiming to maintain that in the same week that the Supreme Court gave a judgment on the state's application to allow evidence gathered in a way in which breaches an individual's constitutional rights, and that such evidence would be admissible in court. Now, obviously the state's case in this instance hinged around a warrant which had been obtained by unconstitutional means. The original trial judge said that she couldn't consider any evidence obtained under this search warrant because the warrant had breached the defendant's constitutional rights, and correctly so, in my opinion. But obviously the state wanted a conviction, so went to the Supreme Court to ask the Supreme Court to change the law so that that individual could be retried and convicted. And the state got the law changed in what Supreme Court Judge Adrian Hardiman described in his dissenting judgment as an abhorrent that is unique in the entire world. And I agree with them. This is an incredibly serious development. I mean, the statute that we're voting to retain here about sheriffs not being allowed to issue illegal warrants is being contradicted by the Supreme Court, allowing the Gardaí to get evidence by unlawful means and to use that against citizens. It's actually an incredible situation, and we should be really discussing these issues in this House, because that's real, live Irish law that's having real, or could have real, implications on the lives of Irish citizens today. Justice Hardiman described himself as it being achieved through gamesmanship of the worst and most cynical kind by the state. And there's a contradiction here now, that at a time when we're talking about Garda reform and the need for Gardaí to adhere to the best international practice, cross I's and dot T's, be human rights compliant and so on, the Supreme Court is saying that a Garda can obtain evidence and then say, well, sure, I didn't know I didn't know when I was getting that I was getting it by unlawful means, and that breaching somebody else's constitutional rights and pleading ignorance is allowable. In fact, ignorance is being rewarded in this instance, and I think this is a very grave development, and in that sense I wanted to use this time to put on the record the seriousness of this issue, to highlight the fact that there is an irony in retaining the statute that we're retaining about the sheriffs and their illegal warrants, which is one of only 40 out of the almost 6,000 that are being revoked. And yet, at the same time, the state is making sure that rules can be broken on the other hand. I also think it's a little bit ironic that we are allowing time on what are, in effect, dead pieces of statute that would never be invoked, and yet we don't allow real, living, important issues like the 8th Amendment and so on to be repealed. That's the real types of issues that we need to be addressed and to engage our population in, rather than legislation which is in effect dead. Absolutely needs to be tidied up. I salute the efforts of the people who were involved in the project. It's a very worthy historical project, but it's not worthy of us using time in this House when there are so many vital issues out there that this government is ignoring and not allowing be vented in.